Hi, I'm Lucian, a lawyer at PPM Attorneys. I specialize in and I've been practicing cybersecurity and privacy law for over 20 years. The intention of this video is to give a high-level view of the Information Regulator's enforcement process and provide some tips on how to handle interactions with the Information Regulator once your organization experiences a compromise. POPIA Section 73 deals with how POPIA will be enforced. It deals generally with breaches of conditions for lawful processing, but highlights 6 specific contraventions. As a lawyer, when we see specific sections being emphasized, these are the ones that we advise our clients to pay particular attention to. They are, in no particular order, failures to notify the Information Regulator and the data subjects of a compromise. In instances where Information Regulator employees and those acting on its behalf fail to maintain confidentiality, that's taken seriously. Failing to comply with the requirements related to compiling directories open to the public, so that's where people collect your information, put it into a book, and open it up to the public to subscribe to. If they haven't obtained your information or your permission, then there's going to be a problem. In addition, failing to comply with the provisions related to automated decision making. That's something very common across different jurisdictions. Next, failing to comply with the requirements regarding the transfer of personal information outside South Africa. And lastly, failing to comply with those provisions related to direct marketing through unsolicited communications. One that immediately comes to mind for me is Harold, the famous internet flowers guy. We've all seen how prolific his marketing is, and if you've ever tried to unsubscribe, it's virtually impossible to do so. So it's important to remember that one of the Information Regulator's powers is to monitor and enforce compliance with POPIA. It can conduct assessments of public or private bodies, compliance with POPIA either because of someone's request or the Information Regulator can investigate on its own accord. Another obligation or power that it has is to handle and investigate complaints that data subjects have submitted to it or which it decides of its own accord require investigation. Once the Information Regulator receives a complaint, it can take any number of steps, which include not taking any action or acting as a conciliator between the complainant and the subject. These are just 2 of the options that it has. Before investigating the complaint, the Information Regulator must notify the complainant, the data subjects, and any aggrieved person of its intention to investigate. It will also notify the responsible party. In this case, when we talk about responsible party, we talk about the person processing the information, i.e. the subject of the complaint. Once it receives a complaint, it can take any number of steps, which include not taking any action and acting as a conciliator between the complainant and the subject of the complaint. Before investigating the complaint, the Information Regulator must notify the complainant, the data subjects, and any aggrieved persons of its intention to investigate. It will also notify the responsible party of its intention to investigate and allow it to submit a written response. In conducting its investigation, the Information Regulator can summon and enforce someone's appearance before it. It can also compel them to give oral or written evidence before it and produce any records it considers necessary. It's also empowered to enter and search any premises occupied by a responsible person. Importantly, such searches may only take place if the Information Regulator has obtained a search warrant from a judge of the High Court or a magistrate. Importantly, warrants can also be issued for searches to be conducted without notice. These are the so-called dawn raids. When executing the warrant, the Information Regulator is required to comply with certain steps, such as executing the warrant at a reasonable hour. In other words, they can't pitch up at 2 a.m. Importantly, the warrant does not extend to seizing communications between a legal advisor, and the person who is the subject of the search. This can be a tricky area, so be particularly pedantic in ensuring that these sorts of communications are capable of being identified. You should ensure that when dealing with your lawyer, you at least mark the documents, if you can, as privileged or as confidential legal advice, and that will help identify those documents if a raid should ever occur. If you do object to certain information being removed because it is legally privileged, it will likely still be removed, but this must be done in such a way that allows a high court to decide at a later stage whether it's indeed legally privileged before the Information Regulator can have access to it. The Information Regulator can also take a less drastic approach in conducting an assessment or in trying to determine whether POPIA has been contravened, and it does this by issuing an information notice which requests certain information to be provided. This is a much friendlier approach and involves a bit of correspondence between the Information Regulator and you, the responsible party. There are processes and time periods that also need to be followed as far as warrants are concerned. So consider the section on warrants carefully too. If the Information Regulator has conducted an investigation of a complaint or an assessment, it may then refer it to a body called the Enforcement Committee. The Enforcement Committee will then make a recommendation on the action that the Information Regulator should take. The Information Regulator may prescribe the procedure that all parties concerned will follow when dealing with the Enforcement Committee. Basically, this will set out how correspondence will occur, what time periods will apply, and how information will be exchanged. The Enforcement Committee can then make recommendations on what the Information Regulator should do to remedy the responsible party's breach. The Information Regulator would then issue an enforcement notice that would set out what the responsible party is required to do to remedy the activities that breached POPIA. This summary of the enforcement process that I've just provided is very high level. There are quite a few intricacies that need further consideration, but which cannot be dealt with in this video. If I were to give you a few tips, they would be the following. If the Information Regulator contacts you and requests records or access to your premises to conduct its investigation, don't be obstructive for the sake of being obstructive. Cooperate with the Information Regulator, but don't be supine where you believe due process isn't being followed. Get your lawyers involved as early as possible. You may also have the opportunity to challenge the warrant before it's issued. So if there is an issue with the warrant, what will happen is that your lawyers may pick up that there is an issue and let the Information Regulator know, and that may delay the process or even put a stop to the process. The next, of course, is to make sure that you contact your lawyer as soon as a dawn raid is conducted or when the Information Regulator pitches up with the warrant. It's possible that the warrant may not have been properly issued. For example, due process may not have been followed. The same applies to any subpoena you get earlier on in the process. It's not unusual for a regulator's summons to be set aside, particularly where the issues which the summons seeks to address are outside the regulator's powers. We have a term in South Africa, in South African law, called the ultra vires doctrine, and it might well be that the Information Regulator is acting outside its powers. So looking at a recent breach, you'll see that Optus's parent company, in the major breach that occurred in Australia recently, its parent company, Singtel, immediately after the breach came to light, announced that it had briefed lawyers to assist it with regard to any regulatory investigation and the contemplated class action lawsuits that were being spoken about. As you can see, the process can be quite intricate. If you need good, clear, precise advice regarding complying with POPIA, or for us to represent you before the Information Regulator when matters go pear-shaped, please contact us and we'll be glad to assist. For further information on POPIA, cybersecurity, and any other aspects of ICT law, please follow us on any of our social media channels. Until next time, thank you for watching. Bye-bye.